We're
Sorry.
supposed to have like a, no, let's all go to the lobby.
No,
Okay.
you're good.
All right. Okay. Yeah, you guys want to see that one. All right. This is a biggie. Okay. There's always civil rights stuff in the AP exam. Always. Okay. So we're going to talk about Ryanair first of all. This is the first one. It doesn't happen until right before the Civil War. It may be the primary cause of the Civil War. This is what happened. Don't write this down just so you'll know, okay? A man named Sanford had taken his slave, Dred Scott, to Minnesota. They went there to buy horses, okay? Well, when they're up there, Sanford dies, and of course, Dred Scott is still alive. Scott claims that even though my master owned me, he's dead now, and I am living in a free state. That means I'm free, okay? Well, when his wife tried to get him back to Missouri, they filed a court case. And it goes all the way to the Supreme Court, okay? And that's Dred Scott. Guys, this is a big deal, okay? Remember, all throughout the antebellum period, slavery, spread of slavery was the issue that dominated everything, especially the spread of slavery. All those compromises, Missouri Compromise, Compromise of 1850, Kansas-Nebraska Act, all that stuff was trying to find a niche to deal with the spread of slavery. This solved it once and for all. Okay? So, first of all, this is what this one says for the first thing. Okay? When Dred Scott claims he has the right to be free because he's living in a free state, and then he claims he has the right to appeal his case to the Supreme Court, Judge Taney says, no, a slave has no rights. So the first thing in this that pretty much damns the whole case is the fact that Taney says that a slave has no rights that a white man is bound to respect. So it establishes the legal status for slaves. Is everybody good? Second thing, okay, all those compromises, dead and gone. Okay? The federal government is in charge of this. They're not going to allow the states to develop their own slave policies. So all those compromises are void. The Missouri Compromise, the Compromise of 1850, they're gone. The federal government will decide the issue. Okay? Let me get to let's look at this one first, okay? And the issue is this, and this is important, okay? Under the Constitution, a slave is a piece of property, okay? It's not a citizen, it's not a human being. It is a piece of property. And the Constitution guarantees that any citizen of the United States can take their property anywhere else in the United States and no one can stop them. Whether it's a mule, whether it's a wagon, no matter what it is, that the federal government cannot impede property across state lines. And since a slave is property, slaves can go anywhere. Nobody can stop the spread of slavery. That's the bottom line right there. Dred Scott says you cannot stop the spread of slavery. Okay? This is a victory for Southerners who had always claimed that. Okay? But it's going to steal the resolve of Northerners who tried to prevent it. So what Dred Scott is saying here is you cannot stop the spread of slavery. The only thing that can stop it is a constitutional amendment. Okay? And of course, at that point right there, when people realize you can't stop the spread, it's pretty much gone beyond the point of control. Okay. Guys, if you think and remember the last second compromises in the Civil War, and that'll be in a later thing we do, the Crittenden Compromise. The Crittenden Compromise offered a constitutional amendment, okay, that would allow slavery to be spread anywhere as long as where it currently existed. Okay, it wasn't a bill passed by Congress. It was a constitutional amendment that would say slavery can exist in the states where it currently rests. It cannot spread. The reason Crittenden introduced a constitutional amendment, okay, is because it would have to overturn that. Okay, and of course, ultimately it failed. All right. So this is going to establish that slaves can go everywhere. When the war is over with, this is still in play. So to overturn Dred Scott, Congress passes the 14th Amendment. Those are important things to know about. The 14th is probably the most important amendment in the Constitution, because that's the one that guarantees due process by law. It also guarantees your individual civil liberties. If you have any questions, guys, just speak up, okay? If you have any civil rights questions on this exam, dump these court cases in them wherever you can. They're a big deal, okay? All right, next one. Big E. In fact, we'll talk about one. You'll see one on the test tomorrow that deals with the case that overturned this one, okay? This is the one that happened in Louisiana, okay? When Homer Plessy, who was an octoroon is someone who's defined by 1/8 black blood, okay? That sounds kind of crazy, but if you come from a place like New Orleans where everyone is mixed race pretty much, because of the social hierarchy, everybody knows everybody else. And everybody knew that the Plessy family was mixed blood, even to the extent. So everybody knew that Homer Plessy was an octoroon, okay? And by the law, octoroon means black. If you remember the reading I gave you, I put a picture of Homer Plessy in there. And the reason I did that, if you look at him, this man doesn't look black. There are no features that would identify him as black, okay? So, he's going to get on a train in New Orleans, and he wants to go to Lafayette, okay? When he gets on the train, the conductor says, you can't sit in the front car because you're black. You got to sit in the back car, okay? And he refuses to get out, and they have him arrested, okay? Ferguson is the name of the railroad company, okay? This case will be appealed all the way to the Supreme Court. And the issue is this: is it fair, is it legal to segregate people because of race? Okay? So, this is what the court case says. Yes, you can. It is legal to segregate on the basis of race as long as the facilities are equal. Tomorrow, you guys are going to read an excerpt of the platform for the Dixiecrats, okay? It's very interesting, the first line of that platform. Remember, this is 1947. And the Dixiecrats are going to say is, we believe in segregation. We believe in segregation is the only way to guarantee the health of both of the races, okay? So what he's pretty much saying here, he's pretty much mirroring this. Remember, this is for Brown versus Board. He's mirroring this. They're saying here that, first of all, America realized that neither race wants to be integrated. Blacks want to be with blacks. Whites want to be with whites. Any attempt to forcibly do otherwise will result in violence. They were definitely afraid of a race war. Okay? So the healthy thing to do is to let the races go their separate ways. Just make sure that the facilities are equal. Okay? Here's the problem. It doesn't tell you what equal means. We're going to talk to you guys later about a court case called Sweat versus Painter. Okay? This is during the 1940s, 1950s. And an African-American student wanted to go to law school. So he applied to the University of Texas. Okay? And Texas says, no, you can't go here. You're black. Okay? It's very awkward. Okay? So he came up and said, hey, look. Okay? You have to let me go here. The 14th Amendment guarantees me that right. Okay? So the University of Texas said, okay, this is what it guarantees you, okay? We will let you go to law school, and we're going to segregate you as long as the facilities are equal. So they took him, and they took him out back to a shack, okay? In fact, they took him over here to Houston. They built him a shack, they put him a desk, and gave him an old law book. That's the same thing we have at UT, okay? That was their definition of equal, okay? Eventually became overturned. That shack later became Texas Southern. That's how Texas Southern first got its start. But it was based on this. You got to define what equal is. When Linda Brown filed her class action lawsuit, their thing is this. Have you seen the new school? Have you seen the old school? You tell me what's equal. Okay? So that's the basis of this. Okay, is everybody? Yeah, Shannon?
What is Ferguson again?
Ferguson was the owner of the rail line of the railroad company. Okay. Okay. You better know this one.
Mm-hmm.
You guys should have heard about this in middle school. It's kind of cool that an 8-year-old little girl brought down all this stuff. There's a little bit more to Brown versus Board than the fact that, first of all, okay, it's going to desegregate public schools. That's the big thing. Chief Justice Earl Warren is going to say that anything that is segregated is inherently unequal. The fact that you segregate means that they're not equal in some way. Okay? So you can't possibly have separate but equal. You're getting constitutional law from Justice Scalia,
Oh my gosh.
the one that's still alive. Okay. Come on, that's funny. Okay. Okay, everybody good? Okay. It's going to overturn Plessy. It's going to defeat that concept of separate but equal. Oops, I'm sorry. Yes?
So, like, who came up with that concept, and why was that, like, okay?
What, separate but equal?
Yeah.
This one right here? That's a good question. Yeah, that's a really good question. Guys, look. In the 1890s, one of the great fears, especially in the South, okay, is that when you keep these 4 million people enslaved for all those years, they sort of have a built-in agenda. Everybody's afraid of a race war. Everybody's afraid that African Americans will pick up weapons and take their revenge on it. Even Lincoln had that fear. Okay? So there's a fear that if you sit here and you mix the races, okay, you're kind of playing with fire. If you keep them separate, they can't fight. There will be no race war. And worse than that, they can't interact, they can't marry, and you won't have mixed race people. Okay? So it's a purely racist agenda here. So in their mind, the best thing to do is to keep them separated. If you keep them separated, each culture grows up within its own culture. Okay? So that was the mindset then. And that brings up an important point. Guys, when you're thinking about this stuff, consider social attitudes here. Social attitudes in 1896 had not evolved nearly to the way they were in 1954. Okay? At this time, it was still appropriate to consider African Americans as them. Okay? As something lesser than human. They had a tradition of a couple hundred years of slavery here. So a lot of times in Supreme Court cases, they will reflect the social attitudes of the day. That is one reason why it's hard to teach the years leading up to the Civil War. It's hard for me to teach. Because I have to tell African American students, okay, that there was a time in this nation's history where they were things, that they weren't human beings. And it's hard to do. It's hard to tell a student like that, okay? But from the perspective of that time, everybody, North and South, always remember, guys, this was never an issue about slavery. It was about the spread of slavery. And that's an example of how attitudes, social attitudes, will affect history, especially in Supreme Court cases. Along those lines, Brown versus Board is the first great civil rights court case. Okay? It's the first time when African Americans start attacking Jim Crow. They start attacking discrimination. They start attacking the way things are. Okay? And there's something else about Brown and Board that you need to know. Okay? African Americans have learned how to fight the system. Okay? African Americans have learned that maybe W. Du Bois wasn't quite right with ceaseless agitation. And guys, one of our things we'll talk about will be civil rights history. This is what this shows them. If you want to fight the system, take them to court. Okay? That's the big lesson out of this. And you'll start to see an increase of court cases because of that. Okay? Now, one more thing before we leave this, and listen carefully. This is something that's important about Brown versus Board that usually you don't hear in textbooks and stuff. Not everybody was thrilled to death with this, okay? Especially southern states. Southern states said, wait a minute. It's not an issue of black and white. It's an issue of the 10th Amendment. The government does not have a right to tell us how to educate our kids, okay? So you start to have pushback, and this is something, again, we'll talk about later on. You start to have pushback. I was telling Ms. Hanson, I talked with a man in Virginia he was in high school in 1954. Okay, when Brown versus Board came out, the county of Sussex, Virginia, shut the entire county school system down. Because if they had stayed in operation, they would have had to adhere to this. They shut the school system down and homeschooled their kids for 5 years, just so they wouldn't have to abide by Brown versus Board. Okay, so you will see pushback, and the major pushback is this. You need to know this. Okay, it is just as much a 10th Amendment issue as it is a racial issue. Okay, it could have been in front of the Marshall Court, and the reason is when it comes to public schools, who has the power to control them? The federal government or the states? Up until Brown versus Board, it was the states. Brown said no, the federal government does. And that's going to open up a whole new can of worms. Okay? This is something that's going on today, especially in this state. Okay? Just to kind of give you some foresight, when the Bush administration came out with this wonderful thing called No Child Left Behind, okay, it was a mandated set of standards that each state had to follow. If you didn't follow the national standards, they would cut some of your federal funding. Okay? Some states opted out of it, including Texas. That's why we take a STAR test and not the national test. Okay? We said that only Texans know how to educate Texas kids. We don't want the damn federal government in our business. And we are still like that. We're still like that, okay? So this issue of the federal government versus state is still a hot topic when it comes to public education. Because guys, who pays for public education? The state taxpayers do, not federal taxes, okay? So that's an issue that you may hear again, okay? And guys, that's called synthesis. When you take something like this and you bring it into contemporary times, AP readers love to see this. It means that you can take something historical and apply it to something that's topical. Okay? So that's why we tell you these things, not necessarily because we're on a tangent, because I'm the king of tangents, all right? But because it matters to you. Okay, is everybody good? All right.